I'm Buck Vosell, and welcome to Legal Talk. I'm a third-generation Vero Beach lawyer, and we're here to talk about current legal issues and issues that are important to our viewers. With me today is my guest, Bobby Guttridge, a prominent criminal defense lawyer here in Vero Beach. And we wanted to talk today, Bobby, about a couple of things. There's been a recent flurry of news articles about Denise Harvey.
Right.
And she's the lady who is now in Canada that was convicted and received a 30-year sentence for having sex with an underage friend of her son's, who I believe was 16 at the time. Is that correct?
Right. Yep.
Now, Bobby, tell our viewers a little bit about your involvement with the Criminal Defense Lawyers Association here in Vero Beach.
Okay, well, I've been here in Indian River County as a criminal defense lawyer for 15 years, Buck. As far as that goes, I've been involved with the Indian River County Criminal Defense Lawyers Association for most of that time, probably 12 years. I'm a former president of that organization. I was a former board member of the Florida Association of Criminal Defense Lawyers, which is the statewide organization, and I'm the current treasurer and secretary of the Indian River County Criminal Defense Lawyers Association.
Okay. Now, Bobby, my practice is all civil. It involves serious injury and contracts and business disputes, and your practice is strictly limited to criminal matters, is that right?
That's correct.
Okay. Now, with regard to these penalties that are assessed, perhaps you could give our viewers a little bit better background or idea of what is legal in the state of Florida and what's not. I mean, when does one of these sexual encounters that these kids are having in high school, they call them hookups now, when does that become something that's illegal, and what should parents of teenage kids watch out for, and should they realize that there are things that their kids could be doing that potentially they could end up getting sent to jail for?
Well, sure. First of all, anybody that is past the age of majority, over 18 years old, has to be careful of having sex. Of course, you can have sex with, an 18-year-old can have sex with a 17-year-old, but once they get below the age of 16, there's potential criminal liability.
Is it 16 or below?
16 or under 16.
Under 16.
It's under 16. They are facing a criminal prosecution as an adult. Probably the more perplexing of the things is, with regards to kids in general, is theoretically anyone under 16, say a 15-year-old having sex with a 14-year-old or a 15-year-old for that matter, can be charged in juvenile court, or if the state chooses to, even upgrade those penalties to adult court. But you are committing a crime merely by having sex with someone who is under 15, even if you're under 15.
Wow. Now, Bobby, let me ask you about the Denise Harvey case, because it's been so highly publicized. My understanding was that the young man who was, I guess, the victim was 16. Did it start when he was 15? In other words, how did this result in such a high sentence? What are the sentencing guidelines?
Here's how it resulted in such a high sentence. I actually ran the numbers on how they came out to the 30-year sentence before I came in here.
Well, our viewers would be interested in that.
And let me just tell the viewers out there, first of all, there's been a lot of talk back and forth about what the judge can do and what could have been asked for. 30 years was actually the minimum sentence under the guidelines as the legislator has laid them out. And so to some degree, the judges have limited discretion as to what they can do. They're somewhat bound by these guidelines, and that was the minimum sentence under the guidelines. And here's basically how they got to that. She was charged with 5 counts. Each of those 5 counts carried a certain amount of points. But the problem in sex cases is you get this kind of physical contact. If you have contact, just basically touching or that doesn't, something short of intercourse.
The petting type thing?
Yes, you get a certain amount of points for that. In her case, she was charged with having intercourse 5 times, and that's 80 points. Basically, 5 years. It comes out to about 5 years additional for every time you have intercourse onto the top of it.
Now, this kid was 16. Does that make a difference that he wasn't 15?
It does make a difference, but the way she was charged with just what's called lewd molestation, and that offense in and of itself isn't really what caused her to score so many points. The offense, just being charged with it, scores 36 points, and that doesn't really mean much, but that is not a mandatory prison sentence. It's just the act of intercourse being added onto it. And so once you added up everything, she ended up with a minimum sentence of 30 years.
What's the difference between this lewd and lascivious type behavior and what some of our viewers may have heard as statutory rape?
Well, the lewd and lascivious battery is statutory rape.
Okay.
It doesn't require consent on the persons. In fact, consent's not relevant. In most cases, you cannot even bring up the fact of whether they consented or not. It's not a relevant factor because you're deemed not to be able to consent because of your age. And that is what is typically known as statutory rape.
But we've got a limited amount of time, Bobby, but let me ask you, viewers have seen some of these cases with teachers and students in other parts of the state, and they go to jail for, a couple of months, or they get probation. Why not that type of a sentence in this case? Why the 30 years that child molesters don't even get?
Well, the problem is that once it goes down to a trial level, and this case got trialed, the judge is constrained by the point system. That would have had been a decision that was made by the prosecutor at the time. You can negotiate any sort of a deal that you want to. If they wanted to agree to a sentence of probation or any other sentence for that matter, they could have done that. The judge could have approved it, and that could have been the end of the case. That just isn't what happened here for whatever reason. Either that wasn't presented to a lawyer, or they just decided to go the trial route.
And as a trial lawyer in the criminal arena, I guess a lot of times in a case like this, you're hoping that the jury will be somewhat sympathetic to your client.
Of course.
All right. Well, Bobby, thank you for being my guest today, and we look forward to having you back again sometime. Thank you again.
Thanks a lot, Buck.
You're watching WWCI Digital 10 Vero Beach, your hometown station. Indian River County History is on display at the Vero Beach Railroad Station, located at 2336 14th Avenue. The station was opened from 10 a.m. to 2 p.m. on Saturdays from September through May. Admission is free. For more information, call 778-3435.
Indian River County history is on display at the Vero Beach Railroad Station. Located at 2336 14th Avenue, the station was originally a stop on the Florida East Coast Railway. It was purchased by the Historical Society in 1984 for $1 and opened in 1987 for visitors after being moved from its original site. The centerpiece of the museum is a display featuring a model train traveling through Indian River County as it was near the turn of the century. Models of historic buildings and old photographs recreate times past as an audio tape guides visitors on their imaginary journey. Other exhibits include displays of natural history, both current and prehistoric, Indian artifacts, train memorabilia, industry, and agriculture, as well as Indian River County's contribution to the war years. The museum is open from 10 a.m. to 2 p.m. on Saturdays from September through May. Admission is free. For more information, call 778-3435.
You're watching WWCI Digital 10 Vero Beach, your hometown station.